address a topic that we haven't talked about before, and that's patentable subject matter. And I'm on the patent doctrine panel. I'm not sure if I should be insulted by that or complimented by that. I'm not really going to be talking much about patent doctrine. I may allude to it generally. A lot of what I'm going to have to say is similar to what Kevin just said, in that I'm going to focus on a consequentialist approach to defining patentable subject matter. But aside from that common ground, everything else he said was wrong. So I'll try to explain why. Now the title of my talk is Abstract Ideas 2.0. Thought it was clever, probably not. I started writing it after Bilski, and then I said to myself, why bother? The Federal Circuit's going to ignore Bilski. They said machine or transformation is still an important clue, so they're going to say it's an important clue, so it's the only clue, so we're going to use it. Because we don't know what the heck this preemption test really means. And they did. So then we got Mayo versus Prometheus, and they still kept with what they wanted to do, the Federal Circuit. So then we got association for molecular pathology versus Mariette. Still not clear the Federal Circuit was getting the message, so we get Alice, and over the last year or so since it's been decided, we've had 12 patentable subject matter cases at the Federal Circuit. 11 of them have said no, and one DDR said yes, though it's not really clear why. And it's pretty hard to distinguish from some of the other cases. So now it looks like it's getting to be timely to write it. Probably we're going to hear about legislative proposals of codifying these exemptions or abolishing these exemptions or modifying these exemptions. That's certainly going to be on the table, I think, over the next few years. But it's entitled Abstract Ideas 2.0 because we've done this before, right? In the 70s, these are old doctrines. These exceptions were recited a long time ago. Though if you go back before, say, the 1950s, it was not really clear if they were real exceptions or something else was problematic about some of the inventions where they were raised. So the telephone case or the telegraph case, not really clear if it was a patent subject matter or simply an enablement problem or an overbreadth problem. And the language was unclear. And so it wasn't really until the 70s when we got Benson, Fluke, and Deere setting down rules that these in fact exist. These three, the holy trinity of exceptions, laws of nature, abstract ideas, and natural or physical phenomena, of course switches its language there and so on, are patentable, are exceptions to otherwise patentable subject matter. And then we sort of spent, this was Abstract Ideas 1.0. And so the CCPA initially under Benson and Fluke, and then subsequently the Federal Circuit after Deere took it over. Not really clear they were trying to honestly implement what the Supreme Court said or had their own agenda, but they did spend sort of 30 years wandering the desert. I think Peter used that euphemism in your article on these issues, and that's a good metaphor for it, right? They cycled between various tests, Freeman, Walter, and Abel, sort of otherwise statutory. And then they got to Allopat, State Street. Allopat kind of the start of State Street, but really State Street and AT&T, useful, concrete, and tangible result. And then Bilski, machine or transformation. And of course the cycling didn't happen just because the Federal Circuit was bored and the clerks wanted to say, what new test could I come up with? The cycling happened because the tests they came up with didn't work. And so the problem with Freeman, Walter, and Abel, the primary problem, so we're going to be talking about first principles in a little bit, Catherine. So I always think of first principles, you've got different sorts of first principles. One first principle you might have of a law is that it actually be capable of being consistently applied. And Freeman, Walter, Abel were not. And so you'd get cases where you'd get AI systems, sometimes drafted as process, sometimes as a system or machine. Sometimes the AI process claim would survive, sometimes it would be struck down, sometimes the machine claim would be struck down, sometimes it would be upheld. The Iwahasi-Graham's Warmerdam sort of trilogy in that area sort of lay out all the various possibilities. So it couldn't even consistently separate things that look pretty similar from a technological perspective in terms of the problem being solved and put them on one side or the other without regard to whether you were on the right side of the line, but they couldn't even put them on the same side, even though they were similar. So I think that's a big part of what led to Allopat, State Street, and AT&T. Now the useful, concrete, and tangible result, what it had going for it was always consistent, because everything was patentable. And so the problem it had was that it didn't get the answer right. That is, that there were some things that we thought ought not be patentable that somehow snuck in. And this led to Bilski, which was probably a paradigmatic example of something that everyone agreed from the examiner, from the panel on Ipsc to the en-banc court, except for a few dissenters, all the way to the Supreme Court, thought should not be patentable subject matter. So they all agreed on that, they just couldn't agree on the test. So the Federal Circuit started with machine or transformation, and it might have worked to be a pretty consistent test, and one that got the answer right, but we never got to see it develop. Instead, we get the Supreme Court stepping in with its sort of preemption, point of novelty, all the stuff we had seen back in Benson and Fluke, and it didn't work then, so I'm not sure why the court thought it was going to work the second time around, but they're going to try and put that into operation. And then they kind of stepped away from those notions with Mayo and then subsequently Alice. So, two-step test, I'm from Texas, so I know how to two-step. Right? Is the patent claim directed at an abstract idea or a law of nature? I'm going to put the natural processes or phenomena to one side for a little bit. And if so, does it add sufficient elements? Is there an inventive concept? Now, it's called a two-step test, and these are the two steps. In practice, at least, the Federal Circuit so far, we only have the 12 cases, and we'll see what will happen, seems to be more of a one-step test. Because every patentable invention that has claims that actually work have a natural law or an abstract idea somewhere behind them. So applying this to patent claims, the first step should always be satisfied. And indeed, in the 12 cases from the Federal Circuit we have, the first step has always been satisfied. So the question is, what do we do with these sufficient elements? Now, before we get into the second step, let me back up just a step and talk a little bit about what Catherine may be talking about, which is where does these three exceptions come from, right? They have no constitutional basis. They have no statutory basis. Apparently, they're supposed to have a policy basis, and that policy basis is that some things are too fundamental. He was good at rhetoric, not so good at anything else, Justice Douglas. And so, too fundamental to allow to be patented. And I'm not quite sure what that means in terms of being too fundamental and reserved to the storehouse of all men, exclusive to none. But something along the lines of either your monopoly is going to be too large relative to your contribution, or too many people are going to want to build on it, so it's really concerned with follow-on innovation and the impracticability of the licensing regime. Now, of course, when you look at those policy justifications, they actually have no relationship to the court's application of the two-step test so far. Now, I know Becky has argued a little bit differently in the diagnostic inference, as Kevin called it, context. But I think you'd be pretty hard-pressed to argue that anybody was looking to do further research on the Mayo sort of discovery, the Prometheus discovery. I mean, they were really just trying to offer the same test, maybe a variation of the same test to avoid patent infringement, but for less. And it's certainly a problem in the medical field that life-saving technologies with highly inelastic demand curves, if you get the patent on them, you can charge a very high price. But that seems to be the way the patent system is supposed to work generally. In Bilski and Alice, the court, as my children would say, was a cheater pants. Right? These economic principles were abstract ideas because they've been around a long time. Well, the interesting question from my perspective is, what if they hadn't been around for a long time? What if Bilski was the first to come up with the notion of hedging? Or Alice was the first to come up with the notion of sort of the third-party intermediary? Would they then become patentable or not abstract ideas? You couldn't say, well, they're in widespread use because they were just discovered. And so I don't think they're very helpful in that regard. And of course, is association for molecular pathology a different test or the same test? We're really still not quite sure. So I'm going to just leave that to one side. So as I think about it, and I think about these things from an economic perspective. As many of you know, I went back and got a PhD in economics a few years back. And most of you know the reason, right? You're approaching 40, you got your midlife crisis, usual three choices: mistress, sports car, PhD in economics. Really, the PhD is the safest bet all around. So those of you who are not yet there, it's my recommendation to you. As I look back, some of the sports cars look pretty nice. So I'm going to approach it from an economic perspective, and so I'm going to have something to say along the lines of what Kevin has said. And so the purpose of the patent system is to provide a system that encourages desirable innovation that we will not receive in the absence of patent protection without undue social costs. So that's my short summary of why we have it. Now, of course, the patent system is not the only system of legal rights we have that accomplishes that result. We also have copyright. And we also have a third regime, which is no special rights. That is just the ordinary workings of the market against a background of competition. And as between those three regimes, we apply each of them to a given sector or industry with innovation to encourage innovation in that sector, desirable innovation, at a minimum social cost. And those regimes, let's just focus on, for example, copyright and patent. They are tailored and have been tailored over several hundred years to the cost investment and the cost recovery structure of their specific industries or creative efforts. And so we would not want to apply the originality standard from copyright to patents, and we would not want to apply non-obviousness to copyrighted works. Have any of you seen a non-obvious film in the last year? Right, there may be a few. The Matrix, everything else after that, those directors.
Inside Out.
Inside Out might be non-obvious, but a wide array of our cultural properties would not satisfy the non-obviousness requirement. So the first thing you have in these statutes are prerequisites for protection. And what the prerequisites are meant to do are identify gaps in the marketplace where the ordinary workings of the market will not produce desirable innovation. And so the prerequisites are meant to identify those things that will be otherwise underproduced and to provide protection only to them. You don't want to protect things you would get anyhow because you would just be imposing social costs without any offsetting benefits. Similarly, on the backside, in terms of the scope of protection, copyright protects against copying, and innovation in the patent system, it protects even against independent discovery. And again, I think that's driven by the different economic characteristics of these two creative activities. And again, both of them are designed, in addition beyond the copying and independent creation, you have claim construction and patent infringement, literal and doctrinal equivalence. Don't really have that anymore, right, Mark? It died. Doctrinal equivalence.
It's mostly dead.
Whereas in copyright, we play around with things like substantial similarity, which we pretend we know what they mean, and so I'll just pretend as well. And so those are fundamentally different infringement standards because the nature of the protection you need to have in order to give a return that's going to encourage the innovation you want requires a different scope of protection. So it seems to me when we look at what the court is doing that what it wants is innovation that looks like 19th or 20th century innovation, early 20th century, right, before Al Gore invented the internet sort of innovation. And when you think about that, what I'm going to say is sound very surprising. I think the court's exactly right. The patent system, its prerequisites, and its scope of protection have been optimized over 200 years for innovation that had the economic characteristics common to 19th century and early 20th century innovation. Whether we look at Edison and his lab, and inventing the light bulb, and Alexander Graham Bell inventing the telephone, or Jonas Salk in his lab inventing the polio vaccine, their approach, the sort of economic investment they need to have, their trial and error approach using the scientific methodology in a laboratory, created a common cost investment structure in the type of research they were doing. Similarly, the markets they then turned around and sought to exploit had a similar cost recovery structure so that a common set of prerequisites and a common set of infringement rights would, in each case, I suppose, or at least I would argue, enable us to promote desirable innovations in those respective sectors without undue social costs. And so when I look at things like Ipsc, and so here's where I disagree with you, Kevin, right? So at the end of the day, I think you come out sort of in favor of allowing patent protection for potentially at least Ipsc and Alice. And I would say no, because for me their cost investment structure does not look anything like the sorts of things we've typically had in the past systems. They don't require labs, they don't use the scientific method in any real sense, and they don't require the trial and error experimentation that the non-obvious standard and the other elements of patentability do a good job in terms of separating out what needs the extra incentive from what doesn't. In addition, right, their cost recovery structure doesn't look to me at all similar. Now in contrast, I think the court may have gotten a bit too excited and gone the wrong way on Mayo and perhaps on Myriad, though I'm going to put that to one side, because it seems to me the discovery of the correlation between the metabolite level and the dosage of the thiopurine is exactly the sort of discovery that is just like the cost investment and recovery structure the work entailed, the nature of the work that went about it was exactly the sort of work that Edison was doing in his lab, though a different subject matter, or Jonas Salk was doing in his. So it's likely to have the cost investment structure and the prerequisites and infringement scope of the patent system, therefore likely to be well tailored to encourage investment in desirable innovation in those sectors without undue social costs. So I will leave it at that. So that leaves a few minutes for questions. And so, how many questions? Of course, I haven't quite finished the paper yet, so it's a little vague on some of those elements, but that seems to be what I'm trying to get at. Yes?
I have a sheepishly impertinent question, and that is, I'm wondering if there's enough exceptions here that they swallow the rule. Mayo, Myriad 1, Myriad 2, we have a lot of the recent Ariosa versus Sequenom case. We have a lot of biological inventions that were the product of, I mean, laborious toil and research at the workbench that are getting dinged under 101. I mean, what to make of that?
Yeah, and in Mayo itself, right, the court very curiously says, well, we don't mean drug patents. So when Wellcomes Burroughs discovers that AZT can be used to treat HIV/AIDS, isn't that a natural law? And what are the additional steps you've added? Take the right dosage with maybe a buffering agent, which all seem to me fairly standard in the practice. So I did not understand how the court could separate drug patents and say they are not reached by this decision. And it seemed clear to me that if the court started striking down drug patents under Mayo, Congress would be likely to be encouraged very strongly by certain lobbying forces that have a lot of money behind them to change that rule. But I don't think we're yet to the point that nothing's patentable. And certainly in a lot of cases you don't even see patentable subject matter issues raised. But there are areas in biotech and software are going to be among them where we're going to have to figure out what the rules are. And so far, at least in biotech, it's not clear. I mean, this is the one difference from Abstract Ideas 1.0. We had Fluke, we had Gottschalk versus Benson, but we also had Deere that said this is patentable. In the second go-around, we don't yet have the Supreme Court saying, yes, this is patentable. And until we do, it's pretty hard to draw the line because all we have are examples on one side of it. Okay. Thank you for your time.